Welcome to Daily News Analysis by Tathastu ICS. I am Manisha Armugam here to discuss the Hindu news the day 22nd January 2026. Okay, so there is no much articles for the day, but we will see a hand-picked things. Okay, so today I have introduced little more related to how to prepare from current affairs. Okay, so if you are taking any article from the newspaper, you have to keep certain things in mind. Side by side you should have your syllabus as well. Okay, good evening Nikhil. Okay, good evening Sajin also. Okay, so whenever you're preparing newspaper, that time you should have your syllabus in hand. Okay, so whenever you find an article that is relevant to you, directly go to the syllabus and look after it, whether those keywords are given in the newspaper and are they in lining with your syllabus. Okay, so this is a basic and a very important role that is playing, okay, in the UPSC, because current affairs is not about mug-upping or taking the actual things from newspaper. Okay, it is about how and where you could able to reflect these topics and reflect these things in your answers. Okay, so that is what it is important for. Always have your syllabus within with yourself. Okay, we will discuss side by side. Main thing, syllabus and the keywords. Okay, so you will get this PDF in the description box, as well as you can scan this QR code and join our Telegram channel for the regular updates. Okay, so today we will be looking after these articles. First is judicial removal. Recent days we are seeing it in the Justice Verma case also. We have seen it is under the process, and again we got a headline for this. Again, Madras High Court judge is been going through this process. Okay, we will see why it is and what is the procedure. We have already seen it, but we will just have a recap of it. Okay, so again it is important for us in our GS2 paper, okay, for the governance and polity. Apart from that, the second is lowering the age of juvenility for crimes is a step back. So this article is based on child juvenile. Okay, so if there is a child that child have been performed any offences, okay, so earlier it was like kind of a rehabilitation kind of procedures, but right now the article is talking about lowering the age for the heinous offences that a child performed. Okay, so for that the child will be trialed as an adult. Okay, like an adult it will be trialed. So that statement of lowering the age from 16 to 18, earlier it was 16 to 18, now it have been changed to they have proposed for age of lowering to 14 to 15. Okay, so we will see what will be the consequences, what and all will be the nexus that we will be facing. So what would be the betterment if we not changing, or if we are changing, what would be the best thing that would be good for the society. Okay, that we will see. Again, it is important for us in GS2 paper. Okay, also in GS1 paper society when it comes to child. Okay, then critical and strategic materials. Okay, it is important in certain things. Critical minerals that is actually needed for our economical development. Okay, and the strategic materials that is actually needed for our national security. Okay, so we will see what are all these minerals and what is the article about. Okay, then another one is, should corruption charges need prior sanction? Okay, so there is always a dilemma. Okay, so there will be kind of a situation where public servants cannot perform their complete authority with the fear of being told as a corrupted or something. So for that they have given the recent article is talking about whether we need a prior sanction or not. Okay, so we will see this. So Parthasathi mentorship is about to start, so you can join for making your foundation course even more better. Okay, the GS foundation course, those who haven't started their preparation, it will be a very helpful foundation course for you. Pre-sure prelim series, prelims test series who are appearing for 2026, you can check out with our test series, and also BA plus UPSC program if you want to pursue your graduation along with your UPSC preparation, you can go for BA plus UPSC program as well. Chalo. The first article, judicial removal, tough law with loophole. Okay. So, the complete article is about, I didn't underline it because the major of the article is talking about the procedures. If you see the terms and conditions, we have already discussed in the previous sessions also. So, it is completely talks about the procedures, how to remove or impeach the judges. Okay. So, that is why I didn't underline it. Instead, I have written it here. So, as we have talked earlier, so we will be focusing on the GS paper 2. Okay. So, the keywords will be for you the judiciary removal, impeachment. Why I am telling you all this? Because it is important for you to understand where you have to apply this. So, on what basis you have to prepare this article. See, every time I am telling you, article is about an opinion, somebody's opinion on certain issues or an event. Okay, it may be biased or it may be pro or against government. Okay. So, what we have to do is like we have to take the crux from these articles, and post that we have to do one thing is like analysis. You have to just get an idea from it. You just have to get an analysis. Don't reflect these kind of ideas in your answers directly. Instead, take a don't repeat the language in the answers, but instead take an idea about it. Okay, the data, the ideas, and also the reflections of your answers. Okay. Okay, so the judicial removal is one of the keyword. Impeachment here. See, in constitution, impeachment is only used for the president, not for any removal process of judges. Okay, so keep that in mind. This may come in your prelims as in the statement they can twist it. Okay. So, in the constitution it have not been mentioned as a impeachment of judges, instead it is mentioned as removal of judges only. So, impeachment only will be coming for president. Okay. So, basically 124 article 124(4) and subclause of 5 will be coming for Supreme Court judges, and also 217 and 218 articles will be coming for High Court judges. Okay. And also Judiciary Inquiry Act 1968 is also important for us. These are kind of the keywords that we have to focus here. Okay. So, let us move. What is the background? It have been said that Madras High Court Judge Mr. G.R. Swaminathan is not actually following the secular concepts in certain judgments. Okay. So, on that basis, they have quoted that the misconduct or the misbehavior of this particular judge is a threat to society, or it is a huge harm to a society. So, we have to remove him. So, this was the background for it. Okay. Let us not get into more political or issue based thing. Instead, we will be going to our static connection. Okay. So, how a removal of judge will be happen? One, if it is Supreme Court judge or if it is a High Court judge, what we will be doing first? For the Supreme Court judge, it is mentioned that in the 124 article, and for the High Court it is mentioned in the 217 and 218. Basically, this have been given that in the Inquiry Act of 1968. Okay. So, they have the rights and the authority. The Parliament can form the inquiry committee against those judges who have this accusation of misconduct or corruption or any other insolvency or incapacity backgrounds. Okay. So, what we will do, either of the house can be giving the motion. Okay. So, if it is Rajya Sabha, at least 50 members have to give the motion to the speaker, or else if it is Lok Sabha, at least 100 members should give the notice to the speaker. So, that was the first priority. Okay. First step would be that one. Next goes if the speaker has two actions here, either he can approve this notice or else he can deny the notice. Why I am telling you here, the whole article is based upon the issues in this thing. Okay, we will discuss it in deeply. First we will understand the procedure of it. Okay? So the houses need either 100 in case of Lok Sabha or 50 members motion for the Rajya Sabha. They will give this motion to the speaker or the chairman. So speaker or the chairman will be considering it whether it is legible, whether it is legitimate, or we have to do we have to dismiss or we have to accept this motion, that is based upon your speakers or chairman's discretionary. Okay? Chairman's discretionary. Then the speaker will be formulating 3-member committee. Okay? It is actually mentioned in our Inquiry Act. Okay? In the Inquiry Act, it have been mentioned that 3-member committee will be proposed by speaker. It will be consisting of Supreme Court judge, Chief Justice of High Court, and also a distinct jurist will be there as a panelist. Okay, so these 3 people will be inquiring the particular judge who have been accused. Okay, the inquiry will be going on. The evidence based report will be submitted to the speaker. Then if it is proven that particular High Court or Supreme Court judge have been done any mistakes or any other negligence, then the evidence based report will be submitted to the speaker, and the speaker will be proceeding it for the votings. Okay, so the speaker will be proceeding it for the votings. There we need special majority. If it is in Lok Sabha, the Lok Sabha has to given special majority, that is like more than half of the people. You may 51%. Okay, and also that particular house who is proposing for this motion should have 2/3 of the votings of present and voting there. Okay, 2/3 majority should be there. So this is what important. Okay, then if this have been passed, the next step will be the next house also will be passing the special majority for the removal of the judge. Okay, so if this motion has been passed in the parliament, this will be moved to the president, and president will be giving his assent with consultation of the particular judges and chief justice. Okay, so so this is what the procedure. This we have already seen. Okay, whenever you are having notes, try to make it as a flow chart. Okay, so what would be the first step and second step? Okay, and clearly mention who will be giving the majority and who will be needing majority plus special majority. Okay, here it have been mentioned in this article, there is a issue in this. So far we have seen in Justice Verma case also, there is no such High Court judge have been removed or impeached till now. But this article is talking about a issue connected to that. Okay, so if a speaker or chairman is dismissing that motion, so there will be, it is not like it is the members are just like that they are giving the accusation. No, there will be some background, there will be some events based on that, then only 100 members and 50 members of the House of Parliament are giving the motion, right? In case if the speaker or the chairman is dismissing, so somewhere or the other the unworthy judicial personnel is being in the system, right? So there is the main issue, and the major issue is with them only. So if the speaker and chairman dismiss the motion, there will be no further action, there will be no committee formed, there will be no voting in the parliament, and there will be no procedures for the president to move further. Okay? So that is a major issue. So it is completely here. So speaker or the chairman is being a statutory authority there. Okay, so not being biased or not being in the floors of legislature, they are performing a different kind of action here, right? So as a statutory, they are giving the authority like whether that person have to be continue or not. Okay, so the first step itself is a motion. If there is a section for motion have to be eliminated, then what is the purpose of having this such a long procedure, right? So that was the first issue it have been mentioned. And also Act does not mention condition of admissibility of motion. So they have the choice of like either admit or dismiss, but here the author is telling there should be some conditions to admit the motion. Okay, it is taking the hours of the parliament, it is taking the working hours of the members as well. Okay, so it is necessary there should be a condition that to be mentioned for the admission. If the speaker is admitting it, then there should be a proper procedure and there should be proper grounds to dismiss it as well. Okay, then the challenged by court. So if there is, this procedure can be challenged by court also. So if speaker is performing the statutory authority, it have to be, it should ensure that this dismissal or the approval decision should be binding, okay, and there should be a reframe in the conditions for admissible and the dismiss. Okay, this is what it is talking about, not much. Okay, other than that it is kind of a opinionated thing. Okay, but if we give this particular, if we implement this particular admissibility condition, then it makes sure that an unworthy judges will not be pursuing in our judiciary system. So here judiciary independence is also needed, as well as the checkmate of the parliament is also needed. So that they will be going hand in hand. Okay? So this is what mostly about. Here majorly we have to focus upon the constitutional provisions, the procedure, and about the majority things. Okay? Nothing more than that. Next, moving on here. Lowering the age of juvenility for crimes is a step back. Okay, private member bill have been introduced in the parliament. Okay, private member bill is nothing but a member who is not a minister in the parliament. Okay, so if we take ABC as a one party, okay, the ABC is a ruling party. The ministers who works under that party will be called as cabinet ministers, and the rest of the people who have been elected, not given any particular ministry, but they will be part of parliament. So they are private members. Okay, so the bill that has been introduced by them are called private member bill. Okay, so recently the private member bill have been introduced for lowering the age of, okay, lowering the age of child who have committed any heinous offences. They will be trialed as an adult, not as a child anymore. Okay? So the trial process for that child will be like an adult. It will not be like very caring, it will not be very smooth or something. Okay? How an adult offender will be treated, the same kind of trial process will be for the child. So earlier it was 16 to 18 years old. Okay? So this the age group of 16 to 18 age offenders. Okay, so they will be treated as the adult. Okay, in the during the trial process. This have been made after 2012 case of Delhi rape case. Okay, so uske baad hi ye ho gaya. So now the bill is about to bring it this 16 years to bring it down for 14 years. So even the 14 years old child who have committed any offence knowingly or unknowingly or mistakenly, they will be going through the process of trial under the provisions what a adult will be going through, different very sensitive questions, provoking questions. Okay, so this kind of process will be there. So this is have been completely discussed, like what it is, what is the transfer system, okay, and what are all the problems that will be the society will be facing if there is any issues in this implementation. Okay, so these are have been discussed. We will be seeing what it is. Okay, first we will understand what is transfer system. Okay, background I have told you. Okay, after the 2012 case, it have been amended. Okay, the Juvenile Justice Act have been gone through this transfer system where the 16 years old child who have committed heinous offence, okay, so they will be treated as a adult offenders and they will be going through the trial process like that. Okay, so this is what the background is. So coming to the heinous offences, if there is any offence that have been done and the punishment is of more equal to 7 years or more than 7 years. So that is the heinous offences here it has been mentioned. So the imprisonment will be for 7 or more years. Okay. In India right now we are following a child centric juvenile justice, that is, so in India we will not be more harsh towards the child juvenile. So instead we will be having, if any child have been committed any offences, we will be treating them with rehabilitation. We will give them, we will provide them the school education so that they will be keep on in touch the studies, and apart from that we will be having rehabilitation centers, and we will be giving their sports activities to come out of those criminal or a critical mindset, and they will be coming out of it later once they get that access to the society, okay, after releasing or something. If they are coming back to the society, that time they will not be facing any huge differences in their life. There won't be any much trauma, okay. So that is what it is right now in the Indian concern, okay. But here what it is, if we keep on doing it, it may increase the deterrence, okay. So it may somewhere encourage others to other child also, if there is no particular or a serious trial basis is not there, then it may introduce the new child for the higher criminal offences, okay. And it should ensure the accountability as well. So if we keep on giving the rehabilitation methods to them, there we can see another problem, nobody is going to take the accountability. They will be committing the offence, okay, and they will be giving the rehabilitation process, and they will be moved back to the society. But this circle will never end, it will be keep on increasing the offences, okay. And one more thing, in India it is not easy for a child to come out of these prisons or trial, okay, mentally and also physically. When it is socially, it is interacting with other society people, it is not so easy, okay. So based on that only, Indian concern is right now going for the child centric justice. But this the private member bill is telling about, it should be little more than a pampering, it should be a kind of a punishment that should be lowering the offences, okay. So that is what the bill is about. So now coming back to the transfer system, what it will be. So earlier 16 to 18 years will be going through the adult trials, okay. So as per India, the child below 18 years will be considered as a child, okay. If they have any offences, they will be trial in a different manner, okay. So comparatively a soft manner to adults. So this adult, now due to this transfer system, people and in the age group of 16 to 18 will be going under adult trial system, okay. Then here it will be checked, the juvenile justice board will be checking the mental capacity, the ability to understand what the consequences will be there if they, what the offence they have done, what would be the impact. So are they able to understand it or not. So all these things will be, the juvenile justice board will be actually assessing, okay. And also the circumstances of offences, there might be a involuntary happenings also, like to just to protect themselves, they might have gone into these offences that have been consequented into something else. So these will be analyzed and assessed by the juvenile justice board, okay. Here the problem is, not every child will be of same ideology, or they will not be from the same background also, right. So sometimes due to poverty, sometimes lack of education, or sometimes due to self protection, these offences have been done, or else sometimes unknowingly, without knowing the consequences, playfully or unintentionally if they have done, or some child purposefully to take revenge on some other background, okay. So for that also it have been done. So there is a problem in scientific tool that has been assessed, okay, and it will be having unequal outcomes. There is no one particular outcome, because of this only this offences have been done, and they have, based on that they have to trial as an adult, okay. So there comes the problem. unequal outcomes are there, and there is only subjective factors only. It may change, it may vary to a child. Okay, so we cannot go with one particular defined process. Okay, so these are the issue with the transfer system as well. Here, recently 2023 NBRC report have been said that the total crimes, out of total crimes, only 0.5% is being done by the child. Okay. So, when we see the crime rate, it is very clear that only 0.5% is there, and the 16 to 18 years is mostly of 79% offences are committing. Okay. And the age group between 12 to 16 are having 21%. So, here there is a need for a change in the system instead of changing the trial basis. Okay. So, if we are giving enough access to whatever they are lacking, in case food, okay, in case if it is based upon the economic conditions, sometimes it may be a family issues, okay, or the societal issues that they are facing. So, if we fix that kind of a problem, we can bring these offences down. Okay. So, when the evidence is also very less, it is not necessary for bringing those 14 years old child into this adult based trial. So, that is what the article is talking about. Okay. So, children need 14 years, just think about it, it is not huge. Okay. They are just in their adolescence. Okay. They don't, their habit will be like to challenge everything, to explore something new, you know. But here these kind of unintentional or involuntary unfortunate offences that have been committed by them will affect them mentally. Okay. So, they here also they are telling it will be a violation of child rights. Okay. So, if you are pursuing any child with the adult based trial, okay, which is little harsh, okay, it may make them traumatized, okay, mentally and physically also they will become very disconnected with the society. Okay. And things like psychological and social harm that we have already discussed. Okay. Then the contradictory to other international obligations. So, in the UN, India is being a signatory for the rights of child. Okay. But if we implement this changes or the transfer system for 14 years old, it will be a contradictory to our signatory, and this through this we may get consequences from global stages as well. Okay. So, what if we implement this? The rehabilitation object. Okay. So, if you if somebody have did it mistakenly, if somebody have did it involuntarily, they need a forgiveness, and they need to be taught the what is actually needed for the time. Okay. So, how it can be eliminated from redoing it, you know. So, that we have to focus here. So, if we are not focusing on the rehabilitation objective, it may end in serious and heinous offences even more. Okay. So, the age, because see, if there is no rehabilitation, if you put a child in the prison, okay, the traumas they are going through and all those background issues they are facing there, you know, they may be sexually assaulted there. Okay. It is happening in prisons. If you see, there is a lot of issues in the prisons. It is not like just people are committing offense, they are going there and living happily. No, it is not like that. It is very torture thing there. It is actually the place to admit their mistake. It is a place where they can come out of those mentality to commit offense. Okay. Apart from that, now Indian prisons are giving more and more opportunities to learn something new, you know. So, all these are bringing up regenerate energy inside them, right. So, that is what here it is all about, the rehabilitation. If that is not there, if they directly put into the prisons and they are going through certain problems physically, mentally, and also other issues also what they are going through, it may end up them in doing offense again and again. See, 14 years old, they have committed a offense, they will be moving to the prisons, they will be having the contact with serious and even more higher offenders, right? So what if they learned from them, then they are getting the economic support from them, and again they are committing these kind of offences. They will be coming in the circular motion only, there won't be any end to this. So this rehabilitation objective actually focus on putting an end to these kind of things, so that the offense mentality, the harsh mentality will be come out of the individual and the child. Again they can go and face the society, and they can become the good citizen as well. Okay? So this is what it have been mentioned here. So what we have to do here actually, so they have mentioned it is system to be fixed. So here we have to provide proper guidance, we have to give proper rehabilitation. There should be a proactive approach also. So after committing offense, if we are going with any changes, that is not a real outcome. We have to bring the actual outcome and the changes before doing it. So that is a proactive approach here. Okay? So we have to fix the system by training the justice board, okay, juvenile justice board, and also we have to give the committees of child welfare the training how to bring them out of these mentalities instead of giving harsh punishments or something. And early intervention, so there should be a system where a society is providing enough opportunities, enough good environment, so that a child will not be committing any crime. Okay? And there should be evidence based law making as well. As we say, it will become unequal outcomes to everybody, right? So there won't be one particular, it is not objective, it is subjective, it may vary to child. So here we should bring a evidence based law making, as our NCRB have been given that very less contribution of child offenders, right? So based on evidence only we are supposed to do, instead of doing it blindly. This is what they are telling. And a child centric justice that we are going through, it is already in our Indian penal, right? So that have to be carried on, it should not be erased from it. The child based trial should not be erased. Okay? And the constitutional morality, the humanitarian background, the constitution provision of article 14, equality before law, and also the article 21 based on the right to life. Now again they have to face a society, they themselves have a life then. Okay, just because they did a mistake, it is not necessary to put them behind the bars very abruptly. Okay, and instead we can give them a chance also. So that is what it has been told. As it is, see, it is a child, end of the day it is a child who is doing it, they might not knowing the offense consequence also, right? So here we can treat them, we can give them an opportunity, then we can change them also. So that would be more better. Okay? So this is what in this article. Moving on. Okay? Moving on to other things, strategic minerals and critical minerals. See, here this article is all about the ministry have been asked people to do more explorations, because China's current export trend on this critical minerals and rare earth minerals. So these are kind of a check and nexus for India to go with these kind of explorations. So Ministry of Mines plans to intensify mineral exploration activities significantly with primary focus on strategic and critical minerals. Okay. So here we could see, now we are focusing on strategic and critical minerals. First we will see what is strategic and critical minerals. Okay. First, strategic minerals are the minerals that is important for our national security and for defense, like nuclear reactors, all these things. Okay. So the strategic minerals that is basically used for the national security, and the critical minerals that is actually for our economical development, like lithium, okay, for EV vehicles, so that we can give we can go for a cleaner energy, you know. So these kind of things will be coming under your critical minerals. The minerals that like the uranium and for the nuclear reactors will be coming under your strategic minerals. ठीक है, clear till now? Shall we move? ठीक है. So these are very much important for our essential national security and also clean energy. So right now we are focusing on clean energy, and net zero commitment is also with us. So globally we are deciding to move to less carbon emission, right? So for that, instead of depending upon the fossil energy and also other non-renewable energy, we are moving towards this critical minerals and strategic minerals that will help us in moving to clean energy, like EVs we can use instead of petroleum vehicles, right? So these kind of things will be helpful for us. Next, so the energies that have been mentioned here is lithium, cobalt, nickel and copper. So these kind of minerals that actually essential for a national security. Okay? Then here we have to understand that GSI, okay, it have been proposed that 500 projects to be explored in upcoming days, okay, and we can approach NEMT, okay, the trust that gives fund for the mineral exploration, okay, the national level mineral exploration trust will be giving the funds to these explorations, okay, and apart from that, the public private participation should be endorsed. It will be more efficient if we are playing with the private partners as well, but here we have to keep a check, because if you see the granite quarries and everything, okay, the private partners are there, but the problem is there is a lot of illegal mining there, you know. So just think about it, the natural resources has been unconstitutionally they are being eroded, okay, they are being sailed or they are being excavated or mined, okay. So when it comes to these kind of critical minerals, we have to keep a very hectic check or the nexus for the private players, so that only the exploration and the processing will be given to them with a judicial and a nominal level of explorations, okay. It should not affect any other resources of the nation, okay. And here we have to focus on GSI, okay, and also MECL, NMET. For these kind of governmental institutions have to be focused for your prelims preparation, okay. Here, as we have discussed, what is the need for these mineral exploration right now? China's export control on the critical minerals, they are right now playing a different role, okay. They are playing a different game globally, because critical minerals are being very essential for today's geopolitics, okay. China is having huge number of critical minerals, they are, and India is also depend upon the import from China only for these critical minerals. China's act, China's export control for the critical minerals, that has been very crucial for India. So that is why we are going for the further explorations. Second thing is global competition. If you see the conditions for the Venezuela, okay, and also the Greenland. So all these areas actually technically they have the importance of minerals and also the very important biomes and everything will be there, okay. So it is not about only the strategic location, it is also about the resources that we get from these kind of places. So the global competition is all about moving towards cleaner energy, emitting less carbon, okay, and getting net zero emission also. So based on that, we need these kind of minerals to sustain and go forward with the global competition. Also India's idea about clean energy, okay. So here, what is the challenge that has been faced while we are exploring this kind of minerals? Problem, first one is slow pace. There is a lot of nexus, there is no one particular body that mandates this exploration, instead there is various board is being involved here. So there will be a delay in process, okay. So there is a slow pace of decision making and also approval for the exploration. Then next one is over dependence. Again, multiple ministries, multiple boards that have to be approached for these explorations, and also limited private players. Problem here, see, we said public private partnership should be there, right? But here we have limited players, because see, the fund from the government is less to explore all these minerals. If we put, so that only it is a very less private players. Private players have to be mandated, and they should be given a little limited participation, because of these explorations and also the exploitations that generally happens when it comes to the private partnership. So the limited private players is also a problem. It have been connected with the morality of the private partners as well. So if private partners are being mandated or regulated with a particular rules and procedures, then we can go for huge number of private players, because they have lot of investments and they know much more. Okay. Then the funds, though we have NEMT for the fund, still we are looking for more funds for the exploration. It is not just about going to the spot, digging the pit and also exploring all these minerals. No, it is not like that. It is a huge process. We have to select the area, we have to excavate all other things, we have to understand the soil, okay, the nature of the soil. So while exploring or something, there should be no landslides, there should be no casualties. Okay, so the minerals, exploring the minerals should be having a proper environment. Okay, so all these needs a huge fund. Okay, the machineries that we use. Okay, if you see the coal mining industries, it has a very huge machinery. So all these are not built in India yet. We have to import it from Germany kind of countries. So it needs more and more funds. You know? So only NEMT cannot provide all these funds. So we are still lacking in the funds. We have to move towards private partnership as well. Okay. Then for betterment of exploring, what can be done? There should be definitely a regulation. Okay, regulation should be there. Public private partnership should be there, so that the regulation will be with the hands of public, the government, and also the core players will be private people, so that we will be getting proper outcome also. And apart from that, more funds to be allocated to these explorations of minerals, because they possess a huge role in India's economical and strategic growth in further days. Okay. And apart from that, alignment. Here, alignment is about how the Indian government is been with the regulations here. Okay. So how much percentage we have to give. Okay. Apart from that, the major thing with the alignment is how we can go with other countries' partnership. Recently we have discussed about the Latin America, Chile, Brazil. From there we will get these, we can purchase all these critical minerals. So from those countries we can purchase minerals, and also we can go with African countries for the win-win situation. We will give them the technology, we will give them the employment opportunities. In return, we will be getting these minerals. These win-win kind of alignments can be done with Japan, and also with our Australian plate. We can go for the inlined and a cooperative mechanisms for these explorations. Okay. So we will get the technology, as well as we will get the deals, better deals from the other countries. Okay. So the next is about, should corruption charges need prior sanction? Okay. Here, corruption charges need prior sanction. Think about it. A public servant is working. Okay. So he have been accused with bribery or something. All of a sudden, the vigilance team is going on, getting them arrested and everything. Okay. So here, two things will happen. One, a immediate process. Okay. So that works as an anti-corruption. The second thing is like, there won't be any proper notice or something that have been given, so that they will be prepared properly for the political games or some other blame games. Okay, so this is what the background actually with this corruption charges need prior sanction, but here I will show. Okay, Prevention of Corruption Act 1988 have been formed. Okay, so in that actually this have been formed based on the recommendations of Santanam Committee of 1964. Okay, so based on that only the Prevention of Corruption Act have been proposed in the 1988. So here based on if there is any bribery, the official position have been abused, like favorism has been done. Okay, so these kind of things are coming under official position. So if they are misusing their official positions for that, okay, and also if they get any criminal misconduct during their official hours or official period, so this will be considering as a corruption and they will be imprisoned. Okay, okay. So to balance anti-corruption and also the administrative efficiency, so if at all every public servant is given the bribery acquisition, okay, or else any other official position, so that they will be given a inefficiency in the administrator. So if you say if I am rejecting, if any of the public servant is rejecting one particular report, or if there is one particular tender that have been given, okay, so if they are dismissing it or if they are disapproving it, it may comes under like they are giving favorism, and it will be comes under like they are abusing and misusing their official position, right. So for there it will be inefficiency in the administration, so they are not able to perform the fullest of their authority. Okay, so there comes a problem, and also to balance it, the parliament have been amended the PCA, that is here we have seen, no. Okay, so they have amended and they have inserted section 17A in 2018. Okay, so what they have did is there should be a prior approval before inquiring the public servant. So if there is any acquisition, a prior notice have to be given to the public servant, so that they will be having a prior idea and they can give their side of arguments. Okay, there, and it should be given at the stage of investigation, not during the trial basis. Okay, so when they are about to get investigated, at that time this prior notice have to be given through a Lokpal or Lok Ayuktha. Through them we have to given it. Okay, so government will be mandating them to get the prior notice. Okay. The problem here is there may be a misconduct, there may be a usage of this thing as well. Okay, if we give a prior notice, genuine people will be protected. Okay, actually this this provision is to make sure none of the genuine public servant is being affected based upon these acquisitions. Okay, but the problem is the other side of the public servant who actually does any other misconduct. Okay, so they will be getting an alert, you know. So that is the next here. Okay, so when we see the judges judgment of Supreme Court in 1998 Vinith Narayanan case, they told that this prior notice violates the rule of law, which impels that everybody have to be treated equally and with the equal procedures. Okay, so it is against that, it have been mentioned that. Okay, then in Subramanian Swamy 2014 case, it is said that approval to investigation senior officer structure that have been struck down. So if there is any senior officer, they have to go through this kind of procedures. There should be one proper notice. Okay, so that approval have to be there, but that have been struck down. There is no proper approval to be given. They can directly face the inquiry. Okay, that they have been done again in 2020. Justice in the case of Justice K.V. Vishwanathan, the 17A section have to is been implemented to protect the honest officers. ठीक है. So these are the judgments actually based on this thing. Here you have to focus on what is section A, okay, what is the prior stage, okay, before the amendment of section 17A, what is the prior stage, then post that what would be the challenges, okay, what would be the challenges that will be faced by the government or the public servant if we implementing 17A, or if not we are implementing 17A. Apart from that, you have to focus on one more thing is the judgments, Supreme Court judgment, okay, the last verdict should be mentioned in your answers also. So now we will be moving to the challenges, okay. So if we implement this, there will be, if there is any prior notice, the first thing will be excessive protection will be there. So those who have did that offense of bribery or corruption, they will be having extra protection, so that they will not be having proper trial basis, okay. And the second thing is equality before law will be violated, because certain people will be having the prior approval and certain people will not be having. So equality before law will be challenged here, and the administrations like Lokpal and Lok Ayuks have to be mandated here, so that through them only it will be provided, okay. So this is very much important. What can be done is we have to strengthen the institutions like Lokpal and Lok Ayuks for the speedy trials. Instead of giving enough time for them to create the evidences, okay, instead of that we can go for speedy trial, and we can give the authority to the administrations who can actually help, okay. So this is what for the day. If you have any doubt, please let us know, otherwise we will wind up the session. Nothing much, just keep your syllabus from today. Whenever we are meeting, we will be discussing the keywords, we will be discussing the syllabus inline, and also how it is important, like the scope of prelims and the mains, okay. Apart from that, we will be discussing the holistic approach, what is the background and what will be the course of action that is needed, and we will be focusing on what can be the solutions or the suggestions for the betterment, okay. So this is how we will be proceeding. I hope it is clear for everybody. In case if you have any doubt, please let us know in the comments, we will clarify them, okay. Have a good evening. Thank you.